In response to the current civil unrest taking place in South Africa, many businesses have had to close, as you've seen, out of fear of attacks and to ensure the safety of the businesses and employees. Some employees have also been unable to reach their places of work as protesters disrupt entries and exits from communities. Under the Basic Conditions of Employment Act, for as long as an employee tenders their services, even without actual performance, they will have a valid claim for their agreed wages or salary. And that's according to a legal firm. Osborne Molatudi is a labor lawyer. He joins us now. A very good evening to you, Mr. Molatudi, and thank you so much for speaking to us. So let's talk about the current social unrest. What will be the impact on employment in these times? We've seen many businesses have had to shut down. Some will definitely never open their doors again. So there'll be joblessness that is not only due to COVID-19, which has created this crisis situation. This will no doubt drive the hammer further in. The nail further in.
Indeed, and thank you so much, ma'am, for having me on your show. Yes, this will exacerbate the situation further for most of employers in our country, in addition to the COVID-19 pandemic that was already affecting them negatively. So there is a number of options that are available for employers who may not be able to reopen their businesses during the social unrest. The most common one will be for that employer to lay off its employees, but subject to a fair process and engagement with the employees. But at the same time, while that process is underway, the employer unfortunately may not stop paying salaries to those employees as long as those employees offer and tender their services.
So there's one question that I'm thinking here is, you want to go to work, but it's unsafe to do so. As we've seen during COVID-19, some employers summarily dismissing people either out of fear that they may quote unquote bring COVID-19 to their place of work, but there are those who have legitimate fears for their own safety because, as we mentioned, exits and entries have been blocked. So can somebody be fired for out of fear of their own safety not going to work?
Definitely not. And bear in mind that an employer is also under an obligation to provide a safe and healthy working environment. So an employee who is not able to come to work because of the current social unrest may not necessarily be dismissed. At most, the option available to that employer is to temporarily lay them off, or in fact, even offer them special days of absence while the employer is assessing the situation. But at the same time, the employer will be entitled to take action against those employees who can identify, be involved in acts of misconduct relating to either looting or stealing, be it at its own place or elsewhere. Because even if you do something like looting, not at your own workplace, but elsewhere, even outside of the working hours, the employer will be entitled to take disciplinary action, subject to that employer proving two key requirements, one relating to relevance to the workplace, and the other one being the trust relationship that it's broken, because no employer would want to be settled in its workplace with looters and in inverted commas, thieves.
So that was going to be my next question. If an employer sees an employee or employees on either video or live on television taking part in that, or be seen to be taking part in that, do they have a right to fire someone?
Yes, the employer does have the right, and in most instances it will be a summary dismissal, subject to a process being followed. That process need not be a physical hearing. We do have a case law that has developed that says that an employer can actually require an employee to make representations as to why his or her employment should not be terminated. And mostly because of the nature of the offense in question, where the videos are doing rounds, you can imagine you are either a critical component of the employer's workplace or you're the CEO. And, to go through a longer process of suspension and having a physical hearing may actually impact further negatively on that employer. So all what the employer will be expected to do is to comply with the rule, the famous rule of Audi Alteram, give the employee an opportunity to explain his conduct, and thereafter for that employer to make a decision. The safest route, of course, would be to take those representation to an independent person and to make a decision thereupon.
So final question, is there anything that employees, labor unions can do, or even employers themselves? We were speaking earlier on to the Road Freight Association about the rising costs, whether it's capital, insurance, if either claims are denied or just for your premiums, including security. Is there anything that can be done to save jobs, given the circumstances we find ourselves in, very grim circumstances?
Yes, I think this is the time, and I've said this before, that this is the time where labor trade unions and employee representatives in general, and the employees themselves, that they need to change their mindset and look at businesses as something that is a collective and no longer us against them. So yes, in times like this, trade unions are expected to offer some sort of counseling and coaching and guidance to employees that you cannot engage in certain acts which may impact negatively on your on the security of your employment, and even for the growth of that company to employ more people. So this is the time where trade unions have to play that role. I think you may have seen that taxi associations are already taking up the challenge by offering protection to certain malls and properties around the country, because they believe that this is the time where they should be seen as a collective and not necessarily as us against them. And that's the challenge that trade unions have to embrace going forward from here onwards.
Indeed. Together we stand. Thank you so much for speaking to us. Osborne Molatudi is a labor lawyer. We're going to take a quick